I've had a foray now and then into NBA politics. In 2010, I contested an election. I was elected the chairman of Nigerian Bar Association, Abuja branch, and I was in office for 2 years and left office in 2012. Then in 2014, I was elected the general secretary of the NBA and served under Augustine Alege, senior advocate of Nigeria, from August 2014 to 2016. And then I attempted to run for the presidency of the bar in 2018, and I was unjustly and unreasonably disqualified. But that's a matter for discussion some other time. But I practice law presently in Abuja. I've always practiced law here in the FCT, and I intend to remain in it for some more years. Thank you, Dan.
Thank you. In your introductory statement, you said something about we are unjustly disqualified. You said it's a matter for another day. I don't think if we leave it for another day, we would like you to explain exactly why you are disqualified. Is it that you cannot, you lack the qualification to be the president of the Nigeria Bar Association, seeing that you've just finished serving as the General Secretary of the Noble Association?
Well, I sincerely believe that deliberately I was not wanted in that contest. And some have attributed it to the fact that I was not a senior advocate, and some persons did not want to risk having me run in that election and probably achieve the feat that Olumide Akpata achieved a few days ago. Because I say this, when you consider the reason for which I was disqualified, the reason they gave for my disqualification is that I had one that I could not show proof that I had relocated to Nnewi branch. And I thought that was funny because the same electoral committee published their voters register where my name appeared as a voter from Nnewi branch. And the Nnewi branch wrote a letter of good standing to me confirming that I was their branch member. And they also ludicrously stated that they could not verify the branch dues I paid for the years 2016 and 17. And I thought that was silly because in 2016, the records of the payment for bar practice of annual dues for NBA Abuja branch was transmitted to the NBA National Secretariat, and they used that to qualify me as a voter in the election for that year, and I voted. So the record was with the NBA. And for 2017, I gave them the name of the account name I paid into, the date, and dared them to produce the statement of account. And nobody did that. They simply said they could not verify that. It was as if somebody was fishing for reason to justify my disqualification. And I took that in good faith that in any case, let me just say this too. A year before my disqualification, I had been informed that a decision had been taken that I would be disqualified and that it would be tied to letter of good standing, which was not a constitutional requirement. And that accounted for my transfer of my membership to Nnewi branch because there was a crisis in Abuja branch. And the faction that I felt was a legitimate faction was not the faction recognized by the then NBA leadership. And the other faction that I did not recognize, they said they knew I would not go to that faction to get a letter of good standing. So they said if I get from the faction they did not recognize, they would disqualify me. If I go to the other faction, which they know I would not anyway, that faction would not also give me. And to avoid that situation, I transferred my membership to Nnewi branch. And so many reasons were given afterwards. Some stated, well, it wasn't stated in the letter. There's no provision for transfer of membership, for notification of transfer of membership. But the bottom line is that the ECMBA for that year, that is the electoral committee of the NBA, was one of the worst. To my mind, that electoral committee disqualified persons who were qualified and qualified some persons who were qualified. In that same election, some other persons who were not qualified were allowed to contest. But because I do not know the scope of your interview this evening, that's why I said that's a matter for another day.
Well, the explanation to me sounds clear, and it appears that some people were afraid of Mazi, Afam, Osigwe. Why would people, is that a fair assessment to make?
Well, in a manner of speaking, I would like to believe it had more to do with my circumstance than my person. My circumstance that I was not a senior advocate. And then there was that hunger by people, I mean, the majority of lawyers who were not senior advocates who felt that the bar was being run in a manner that suggested that only senior advocates were fit to lead. And there was that hunger by lawyers seeking to also elect a non-senior advocate as president. And also that some people felt that that risk was too heavy to be taken. Indeed, in the run-up to this just concluded the election, some persons even posted on Facebook, persons campaigning for the other candidates that Olumide Akpata was going to be disqualified. So people were also waiting for a repeat of what happened to me in 2018 to happen to Olumide Akpata, the whole solution being don't allow him to run. And when you also take cognizance of the fact that a letter written by Chief Adegboyega Awomolo, warning of the revolution by young lawyers who are in the majority, eager to take over the bar by electing a non-senior advocate, it will give you the kind of thinking among some people that unless you were a senior advocate, you were not fit to lead. And but that is regrettable, considering too that in the past, very many lawyers who led the bar were not senior advocates, and that amongst them are counted among the greatest president the bar had ever produced. And some of them only went to take silk after being president, and some never even bothered taking silk. So, but I mean, I'm glad. I was highly elated when Olumide Akpata was elected president, particularly with the wide margin with which he won that election.
The election you contested and were disqualified to run, I believe it is the outgoing Nigerian Bar Executive. Am I correct?
Precisely.
And it is that same election, I believe also there are matters regarding that election that is pending in the court now.
Well, I do not think so. That matter, to the best of my knowledge, has been dismissed, except maybe you refer to the criminal aspect of it, which only came to light a few weeks ago, that some persons had been charged to court for alleged manipulation of the electoral process. But the challenge by Afam, a senior advocate of Nigeria, one of those who lost out in that contest for the presidency of the bar, to the best of my knowledge, had been dismissed by the High Court of the FCT. And I'm not aware there's any appeal against the decision.
Now, I would be thinking that as an eminent barrister, a senior advocate, well, not in this, well, not in the titular way, but a senior member of the bar profession in Nigeria, when an injustice is committed against someone of your personality, would have sought to seek judicial redress of what you term to be an injustice. And I don't remember you taking that route. Why didn't you seek?
You are mistaken, Dan.
Okay.
There's one unfortunate thing about Nigeria, and that is the fact that people will deliberately disqualify you, knowing that by the time you exhaust the judicial process, the election would have been conducted, and in most cases, the tenure of office of the persons you're challenging would have elapsed by a fraction of time. I recall that during the Brexit debate in the UK, when the Prime Minister prorogued Parliament, the decision was taken all the way from the High Court to the Supreme Court in a matter of days. And the Prime Minister was ordered to bring back Parliament. In Nigeria, you will never have such a situation. Matters of such nature, which you would expect to get some kind of accelerated attention, don't get them. And of course, even if the judge tries to do that, the lawyers involved, especially on the defense side, will accuse the judge of bias, of having taken bribe, write petitions, put preliminary objections, throw everything in the works, make sure that that case did not proceed as quickly as it should be. So most times you see people suffering injustice and not being able to do much about that. But back to myself, I challenged my disqualification in court. I instituted an action in the High Court of Anambra State, sitting in Nnewi, and served NBA. And NBA was represented in that matter. But when, after my disqualification, I also reached certain conclusions, the fact that some persons who were privy or who schemed to disqualify me were also contested in that election, I joined forces with one of the president of the bar and moved my support to him. And when he won, and with certain discussions, I felt that there was really no need for me to continue with the legal challenge to the whole process, since I contributed to the victory of the winner of the process, and I withdrew my suit. Not that I didn't challenge it, I did. And I also was mindful of the fact that with the way the lawyers representing NBA were going, that we may never get to hear that case, because they were bringing all manner of objections, making sure that even my application for injunction to restrain NBA from conducting the election into the office of the president was not even touched. They made it difficult for that application to be heard. And NBA, despite the pendency of the motion for injunction, went ahead to conduct the election into the office of the president. So I challenged it, but I took a pragmatic decision to withdraw it as a result of the outcome and as a result of my contribution to the outcome of the process.
Thank you very much, Mazi. One statement you made now leads us exactly to the topic of this discussion. Nigeria Bar Association, election, and judicial reform. Seeing the state of judiciary in Nigeria today, we would like you to, are you able to make maybe a 5 to 10 minutes presentation, because I'm sure you are aware of the topic we are having today. It is a very, very important topic in the minds of every legal practitioner in Nigeria. What do we do about election? What do we do about judicial reform? Not just election generally in Nigeria, not just among lawyers, but generally in the country. Election, judicial reform. What do you think about that topic?
That is very, very important. And until we address these issues, we'll be burying our head in the sand. Now, if you look at elections conducted between 1979 and 1983, the election petitions or the challenges to the elections were concluded before the winners of before the swearing in took place. And the panels for those elections were consulted by the chief judges of their state. The chief judges were trusted to be able to do the right thing. Now you have a situation where it appears as if there's no trust that being the chief judge of a state, a chief judge would be able to do the right thing. So what happens? The president of the Court of Appeal constitutes an election panel for the whole nation. And what does that give rise to? A judge is taken from Yobe State and taken to Anambra. A judge is taken from Borno to Enugu State. A judge is taken from Plateau State to Ogun State, and so on and so forth. What happens? These judges have their regular sitting, which is disrupted, and they spend about 6 months trying these cases. They leave their family, they leave their judicial work, and the cases pending before their courts are kept in abeyance. And sometimes the elections are nullified, and a fresh election conducted, and you have the process repeated all over again. So why don't we first of all look at what we obtained under the 1979 Constitution that made for quick dispensation of election petitions? Why can't we have situations as you have in some parts of East Africa, where certain election petitions are taken by the Supreme Court, and where most such matters are concluded within 21, 28 days? Why must we in Nigeria have such lengthy periods of time for everything, and at the end of the day, people still walk away believing that justice has not been done? You see, we need to look at these things holistically, and we need to also find out, look at the process that makes the judiciary to be so very much entrenched and involved in the electoral processes. And I don't want to talk about party democracy because it's not part of the discussion today. But the judicial process must be structured in such a way that such cases should be dispensed with. But lawyers, being what they are, must take every move to favor the respondents, to make sure that these cases do not move, to make sure that difficulties are thrown in to make these processes slow. And then again, what do you make of an electoral process? A constitutional provision that says that pre-election matters shall be concluded within 6 months. It gives rise to a terrible situation where, if, for example, you're unlawfully excluded or substituted in an election, if you won the primaries, some person will go on to run for election. People may never know you're a candidate. They vote for the person on the ballot. And then you go through the judicial process and you win. And so the court ordered that since that person won and you ought to have been the person to contest, that you're declared winner. It creates absurd situations, and the Constitution made it such. Why didn't the constitutional situation make it also such that these electoral matters, especially the pre-election matters, are concluded before the elections are held? Why is it that the Constitution does not make it such that this whole electoral process, petition, and appellate process are concluded? Why must the gubernatorial election continue to go to the Supreme Court? The Supreme Court is overworked. We need to look at it, and we need to look at our rules and make them flexible. And make it not to operate in any other part of the world, is satisfied about the outcome of the electoral process. We need to do a whole lot of things about this. And we need to also ensure that we look at what worked much earlier to see that 1999 Constitution introduced so much anomalies in the system, which has not produced a better result. And I think we need to get to the drawing board. And the judiciary also needs to The legislation needs to amend the Electoral Act, which has also prescribed some things about how the electoral petitions are to be conducted. And then the rules of court guiding this practice direction, guiding the conduct of these cases should be done to fast track it. The fact the law says you must conclude within 6 months should not be such that you cannot conclude these things within 2 months or 3 months. We should save time. We should save valuable time and also engender confidence in the minds of the people and reduce the attendant huge cost of prosecuting these cases and the disruption it causes to judicial process. I guess I should stop so far so that you may not.
Well, I can assure you that your speech has raised a lot of questions in my mind that I don't know where to start again. But let me start from somewhere. One of my guests some time ago was Professor Awale Yadudu, the legal advisor to former head of state Abdulsalami Abubakar. He was credited with...
Not to Sani Abacha.
Okay, Sani Abacha. But I think he was credited, okay, yeah, Abdulsalami now appointed him the chairman of the committee that drafted the 1999 Constitution. Yeah, Professor Yadudu was of the view that our Constitution should not go into such detailed, particular provisions regarding a lot of issues. And one of the things he mentioned actually was electoral matters. That our Constitution should be flexible enough to allow the judiciary to interpret some of such disputes like you have mentioned now, like electoral dispute. And now you are saying that our Constitution should provide for instance, allowing electoral matters to be concluded before the election itself takes place. So would you agree with Professor Yadudu that our Constitution should not go into such detailed provision, but allow INEC, for instance, to set the rule rather than the Constitution making such provisions in electoral matters, for example?
I wish he took that advice when they drafted that Constitution.
Well,
because I think there are too many unnecessary details included in our Constitution. I've had the opportunity of reading the American Constitution and I saw how scanty it is.
Yes.
And yet the American Constitution has been developed into a living constitutional masterpiece as a result of judicial action. Yet, despite the unwieldy nature of our Constitution, we still cannot agree on what the different sections provide. And sometimes too, different courts, even of the same court, divisions of the same court, like Court of Appeal, or even some panels of the Supreme Court, may not always be 100% in tandem as to what those provisions are, or how they are to be applied in different sets of circumstances. So our Constitution is unwieldy and has delved into issues constitutions should not delve into. And the fact also of giving so many timelines, you say that pre-election matters, not the word, pre-election matters should last for 60 days.
Yes.
And say that the election should not be conducted not earlier than 120 days and not later than 130 days. What you have, the time you have given for the conduct of pre-election matters now becomes much more than the time for the election. So what, and then if you also consider the way INEC makes their rules, they will not kickstart the electoral process until a few weeks to the time permissible by the Constitution for the conduct of the election. So it is called that there's not enough time to deal with these matters. So why don't we also allow rules of court or regulations made pursuant to the Electoral Act to regulate these things and reduce the time for the doing of these things? But then again, you have the problem in Nigeria too, that when sometimes you also put these provisions in act, the judiciary will strike them down, arguing that an act cannot restrict the exercise of judicial discretion, or the time we did that the law cannot impose a time frame within which the judiciary must decide. So we have a peculiar situation, and we need, and that's what people say that we need to evolve our own system. But I think beyond that, we too must learn too that not everything must go to court. When even some issues are settled law in Nigeria, people will still be pushing them, taking them back to the court, the courts that are already overworked. And maybe we should also look at the model in America and some countries where if a court does not accept a matter for discussion, that appeal is automatically deemed to have been dismissed. It doesn't have to come up for hearing. So if a matter does not raise serious constitutional issues, it shouldn't get to the court, because we should talk beyond the electoral process. Why, for example, would a chieftaincy matter go all the way to the Supreme Court? Why, for example, will a tenancy matter go all the way to Supreme Court? Why will the matter of customary law or Sharia law go all the way to the Supreme Court, where they do not touch on any fresh constitutional issues? Why can't we have appellate courts at the state level that will take final decisions on this issue? And then an appeal can only go by certiorari to the Supreme Court, where it is felt that the highest court of a state, or they call it Supreme Court in some jurisdictions of a state, has violated the constitution, or that there are constitutional issues that has been raised that require the court to delve into. There's a whole lot of issues, because if in Nigeria we focus so much on election that we are killing other areas. The constitution makes so much provision about fast-tracking electoral cases that commercial transactions are dying. So you must conclude the election matters, but then commercial transactions that will encourage foreign direct investment are not encouraged. So because people are afraid that commercial disputes in your jurisdiction take forever, they may not want to invest there. Or when they invest, they commit you to an agreement that allows disputes to be resolved in other jurisdictions.
Mazi, I will still go into judicial reform, but let me still stick with electoral matters for now. I monitored closely the last Nigerian Bar Association election, and I observe everything is done online. Register with your phone, they send you a link, do this, do that. Is there anything Nigeria can learn from the way the Nigerian Bar Association election was conducted?
Well, I think one major thing I think the INEC should learn, and which the legislature should not be afraid of, is that electronic voting should be incorporated into our voting process. And while NBA did not do anything about absentee ballot or whatever, because electronic voting allows you to vote at any time from anywhere. But I think the fact that an election could be conducted electronically and monitored almost real time is very important, because part of the problem you have in our electoral process in Nigeria is that sometimes the results declared at the polling units, collated at the polling units at the ward level, may suddenly differ from what is collated at the local government level or some other level. So people manipulate the electoral process. But where these things occur real time and the results are declared, people don't have to travel through night, carrying papers, being attacked by people, the result sheets being substituted. Is very, very important. So, but I'm not saying that the NBA election is a shining example. I mean, there are some flaws noticed there, which NBA could do well to remedy. Issues dealing with the voters register and the integrity of it, the fact that it was not published until a few hours to the election, and the fact that it took so long to compile it, when we should have done that within 45 days of the conclusion of payment of annual practice fee, and then branches giving ample time for people to challenge it, or to query any aspect of it, or to sort out any issue that may have excluded their name. I mean, we could do a whole lot on that part. INEC seems to have done better in issue of compilation of voters register than the NBA. But the fact of the election being done electronically is this last one seems to have enjoyed much more confidence than previous ones. But then again, I say NBA is still talking about.
But even at that, I noticed that some bar associations still raised the petition, the national body, that some of their members were unable to register, some of their members were unable to vote. So why would NBA seek to, you register to vote in an election, validate it, and still vote at the same day within 24 hours?
I already pointed that out as an anomaly. I mean, it's not right. People should have had ample time to look at the voters register. I mean, it presupposes that you should know those who are eligible to vote so that you know those to campaign to. And I have quite some issues with the conduct of the election. For example, the electoral committee restricting people from campaigning in certain ways without making available to them data on the voters to reach out, on how to reach out. It seemed to be more interested in excluding the doing of some things without providing solutions on which things could be done. And I mean, I have a problem with that. And I have a problem with publishing the voters list by 10 p.m. for an election that was to commence by 10 p.m. There's everything wrong with that. Absolutely everything. And we could have done better, because at the end of 31st of March, the NBA already has an idea of those who paid their bar practice fee or annual practice fee. So NBA should have immediately extracted those names and published them as, and extracted them first as forming the rough list of those who qualify to vote. Then seek branches to send them a list of those who paid branches by that date from their own branches. Since the NBA Constitution says that for you to vote, you must have paid your annual practice fee as well as your branch dues. So NBA should have taken steps to produce that initial draft by 1st of April. And then the branches must send in their statement of account so that you'll be able to, so that within at most 21 days after, by April 21, the voters register must be ready. It's not rocket science, which also presupposes that an electoral committee being put in place before the end of March 31st. And in any case, employees of the NBA can do this phase of it, while the electoral committee can now work with the document given to them and verify whether what they've been given is the right thing to do.
Does this present
the 11th hour to produce it is a no-no?
Does this system give room for fraud? Because if I remember correctly, one of the issues raised with the previous election was allegation that this system of uploading people who are qualified to vote gave room to fraud, and it was challenged on that basis. Does this present system give room to fraud?
Dan, I am a bit reluctant to talk about that, but it gives room for some kind of exclusion, and I will explain in what sense. But then again, it also has to both the voters and the electoral committee may share in the blame. For example, my wife is a lawyer. She paid her branch dues and annual practice fee, but she could not vote.
Why not?
Now, when I sought to go after the election, they explained to me that because they asked me if she had gone to the Supreme Court to change her name on the database. And of course, I answered in the negative and said that could be the problem. But they asked her to, some days to the election, she was asked to upload her call to birth certificate, her marriage certificate, and proof of change of name. And she did that. The supposition was that somebody was going to effect that change, having received these documents from her. And the explanation by them is that if there's a discrepancy between your name as appeared on the database and as appeared on the list of those who paid these fees, your name may not appear in the final voters register. But I also tell you that I know one or two persons who did not do any such change, whose names appeared. I may not know the solution to this, but my take, Dan, is this. A lot of organizations in Nigeria obtain data from people. NIMSI, Federal Road Safety Corps, and then even banks. Whichever way it is, you can find a way of integrating the NBA database and the national identity database so that some other thing, something other than Supreme Court enrollment number can be used to verify lawyers. So when you impute this, and our system is able to achieve a handshake with a government agency database, it will be able to upload your record and even pull your picture. We can do that. I know that with the right IT persons in place, we may be able to achieve this. And so it will be much difficult for the allegations of identity theft, a manipulation of the voting platform to be sustained. I'm not so sure whether, not being a professional in this field, my advice is right. But my thinking is that there could be some other means that will do it. Because I noticed these days that when you go to a bank to open an account, they ask you for your, what do they call that thing? Not BVN. Okay, if you go to register with NIMSI, National Identity Card, they ask you for your BVN. The moment you give it to them, it pulls your record. You will see it. You see the very picture you took the day you went to do your BVN. It will pull it up. So what that tells me is that we could achieve the same at the NBA, because the integrity of the process is very important. We need to, in general, so that if a person loses, he or she will not have to complain that the system has been manipulated.
Another thing I find concerning with regards to NBA election is with regard to the cost of campaigning. I remember I was in Nigeria several years ago when you were campaigning to be the general secretary. I know I just visited I think 1 or 2 branches with you, and I was like, wow. And then I was following your activities online, campaigning in Northern Nigeria. How is there a way to minimize because we also complain of the cost of presidential election in Nigeria. Okay, let me ask this question. What's the estimate? How much would it cost one to campaign to be the NBA president? Now,
can you give us able to know?
No, just give us an estimate, because I know you campaign. Give us an estimate.
That I may not be able to give you an estimate, but I'll tell you it's very expensive.
Really?
It's a one is torn between campaigning online and then also visiting the people you seek to lead. If you understand MBA, you understand that some branches are so far removed that in some sense we call them rural branches. And what you may think are their challenges are actually not their challenges when you get to speak with them. And I do not believe that one can have a fair knowledge of bad leadership if you don't get to interact with these individuals, get to their setting, see the circumstances under which they practice, interact with them, find out what are their needs. So something you may think, maybe for those of us who practice in places like Abuja, Lagos, Port Harcourt, something you may take for granted are big issues with them, very huge issues with them. And I do not think that in order to cut costs, but we need to find a balance, and it's very difficult. And the usual normal thing, when you visit people, either they entertain you or you choose to entertain them even though you're the guest. I mean, campaigns come at a huge cost. I sometimes also look at how much people raise that they are seeking mere tickets in the US. It's expensive. And MBA is not any different. There are 125 branches in the 36 states of the Federation and the FCT. You have to move around. But you can also make it very expensive, or you can make it cheap, but not too cheap as to be. I mean, it could be cheap, but then it involves some form of spending, because there's no way when you move around with people, you pay airfare, or even when you go by road, accommodation, feeding, it's bound to cost money. But one may not be in a position to say, well, it could cost so little or so much, but it costs money, and maybe we could find some ways of minimizing. But to be honest with you, I do not have an answer or a solution to that at the moment.
Thank you very much, Mazi from Osigwe. At this point, we are happy to welcome questions from our listeners. I'll also be monitoring if there is any question on Facebook where we are streaming it live. But our guests here particularly, we would like to take your questions for our guest tonight. While we wait to see if there is any question, my next, okay, well, we have Charles Ude, please. You're already unmuted.
Hello, good evening.
Good evening.
I'm happy to be here this evening. Mazi, I think with the elections, I think we have a problem. If not sorted out in future, that problem will keep reoccurring. Because of my previous background as an IT analyst, I think it's time NBA need to spend money to have proper file system, database management in place. On the eve of the election, I logged in, I was unable to vote. When I checked number of people that were eligible to vote, I was wondering who was handling the information coming in and going out. I was wondering what sort of storage is in place to hold this data. I don't know. So I think whatever we do, we need to spend money. The incoming MPA needs to hire a specialist. You have suggested how they can collect numbers of people who have paid their annual dues and registration, but you need to have an in-house person who will have the relevant servers in place and keep computing and compiling all this information. I think it will go a long way. That's all I just want to add. And I'm happy that we have someone who is fresh, who is not politically exposed, if I may say. Something that Mazi was denied last time. I think this time around, we have been successful. I'm not saying that SN should not be leading the bar. In UK, where I trained as a lawyer, the SRA is not headed by lawyers. You all we need people who can run the place and manage it. then if you have a strong MBA, we can now start handling issues with NJC. We will not be, and this will help even to those who want to amend the constitutions. We'll be able to help with drafting and the rest of it. That's all I want to say. Thank you so much.
Thank you very much, Mr. Charles. Before Afam, please, Afam, take note of what he said. But I want to, in fact, it's one of the questions I wanted to ask. But if you can just deal with it together now. In the United Kingdom, where I currently practice, like he rightly pointed out, the Solicitors Regulation Authority are not headed by legal practitioners.
Exactly.
And that is why we are always, it's very, very difficult to practice law. And that is why lawyers are always on their toes, because any mistake you make, the hammer will land on your head.
Exactly.
So is there any way that the Nigerian Bar Association could separate the disciplinary body of legal practitioners from the professionals themselves? So if you can just answer the questions together, please.
First of all, there need to be some more training. MBA should organize seminars where things like this can be explained. Because there's this, I don't know whether it's a confrontational attitude, like they say it's a Nigerian factor. So we're not ready to embrace anything coming from outside, even if it will help. So we need progressive people in the bar to go around all over the world.
All right, thank you. Okay, let's hear from Mazi at this point. Thank you very much, Minister Charles.
Thank you, Dan. I think our disciplinary process is not entirely under the control of the NBA. Now, NBA receives petitions, and these are referred to disciplinary panels of NBA. And then if they make a prima facie finding, NBA forwards it to the Legal Practitioners Disciplinary Committee, which is a committee of the body of benchers. It is this body that conducts the hearing. And that body, NBA, presents the case as prosecutor, not the judge. And this is very, very important because it is not the NBA that disciplines lawyers per se. But there's a move in a draft bill to bring in laymen into this process, or to bring in, some presidents had earlier proposed appointing a registrar who would do it so that it will not, the political leadership of the bar will not be involved in it. And I think it is worth looking into. And also, there's also a draft bill, a legal practitioner amended bill, which has not quite been agreed on for presentation to the National Assembly, which also suggests that the present situation we have, whereby every disciplinary matter is tried here in Abuja. Every person having to come to Abuja brings about a situation where this process does not move as fast as it should. And then with the challenges of also composition of the panel, there are recent Supreme Court decisions from 2019 that if a panel hears a case and the composition does not remain consistent, and any person who did not participate in all the stages participates, that will void the proceedings. So these are challenges we face. There's actually need to modernize the disciplinary process of the NBA and make it fast, because sometimes the petition may be written against a lawyer and in 5 years, it has not been resolved. And the law is also such that if the disciplinary committee takes a decision against you, the moment you put in an appeal, and it doesn't matter whether you deliberately fail to prosecute that appeal, it operates as a stop proceedings. That also has its own shortcomings. Sometimes an appellant will, for 2-3 years, not compile record of appeal. So he's just hanging in there while the person goes about. And there's also the database for people to know who has been disciplined and who has not, needs to be updated and needs to be made to work in such a way that if you lodge an appeal and you don't take certain terms by a certain day, your appeal will be deemed to be dismissed without need for any judicial action being taken in respect of it. There's a whole lot of work to be done. There is no doubt MBA may do well to study the SRC, or I think you called it, and what of things in the other countries to make the process move faster. In some jurisdictions, I understand, it is the High Court of that state that hears such matters. This chief judge, states where they have Supreme Court, the Supreme Court of that state, probably because of, like in the US, because the people have state bar and people are called to the bar of the different states. So we need to have a process that allows flexibility and makes for speed without compromising justice to be brought into the disciplinary process, so that also, because there's need to protect the confidence of the public, who are the consumers of our services, to believe that the legal profession is able to discipline its own, to be able to believe that lawyers don't do what we call a man no man. We are protecting our own, ourselves from censure, from discipline or criticism of our own. We need to take steps that improve people's confidence in the process.
Thank you very much. Apart from the disciplinary issue, Charles, would they also talk something about database, if I'm right?
No, I totally agree with him. That was why I said that this should be done in-house and handed over to the electoral committee. NBA could do better with data management. We repeat this process every year, and every year it is trailed by criticism. We can do better. And these things should be available months before an election. It's not rocket science. And I know it can be done with the right caliber of persons. I agree with him totally.
I also don't understand this matter of, on the election day, NBA is trying to validate whether you are actually a qualified legal practitioner in Nigeria. What does that? I don't understand, because once you are called to bar, you pay your practicing fee, all your data will be there. I can log in and see everything about me, my areas of law, my litigation practice, my years of experience. They should be there. In fact, an outsider can log into UKSRA and know everything about me today. So why would, on the date of election, NBA will be trying to validate who is qualified to vote in an NBA election?
Well, Maki, I've not been involved in the ECMBA, but I think too, if our mode of payment is made electronic, such that as you're making payment like we do with conference registration, you input all your details, it will help to get this database. So for example, as you put in your enrollment number, it pulls out your name, selects it.
Exactly.
You input your email address, you input your phone number and pay. It forms part of the database for the election. There will be no need to ask you to come again to update your details.
Of course.
And that is what we should do. If you do not put them at the point of payment, your payment should not be completed. Whether you're paying at the bank or you're paying online, we need to do that. We do it with a conference. So why is it that when it comes to conference, we have a better data management? When it comes to payment of annual practice fee, we suddenly apply very archaic and obsolete modes of just to collect your money and nothing more. So we should apply the same procedure we use for conference registration to payment of annual practice fee. And the time to do that is yesterday.
Thank you very much. I'm calling on Otumba Olabode Osene, please. You are muted. Can we hear from you, sir?
Yeah, thank you very much for having me. This is more of a social question than a legal or political. If the NBA or the judiciary is in such a messy, very unbelievable situation, cannot manage the affairs of judiciary, what do you think the ordinary Nigerian will think of? Again, I always refer to I'm also a student of political science and law, and I've been in Europe for over 50 years now. And I always remember that when I first came back, after about 10.5 years in Germany, one of my best friends then is lived now, Alawa Kabashoro. We've gone together to bar meetings where you have the people at different level of judiciary meeting. And I look back, there's no change. And when you now see this century that the executive is in position to ridicule judiciary, is unbelievable that the judiciary is not doing enough to manage the affairs of judiciary. Yes, unfortunately, it's the executive that will hire and fire judges or whatever. But the amount of corruption, the amount of terrible things that is going on in judiciary in Nigeria, you cannot explain it to anybody. Nobody can understand it. So the question is, what is judiciary, or what are the people now managing the affair of judiciary starting from the MPA level? What are you doing to fix this problem? This is a very, very messy problem in Nigeria. Thank you.
Thank you very much. We allow Mazi to respond.
Thank you, Otumba. One of the unfortunate provisions of the Nigerian Constitution is that it allows NBA to have about 5 representatives in the National Judicial Council without giving them a say in the issue of discipline of judges. So once any judge is up for discipline by the NJC, the lawyers by the NBA are not allowed to participate. And the funny side of it is that the 2 lay members of the NJC participate. Another aspect of this issue of discipline is that the bar should play the role of a pressure group. So, and the bar must to be fearless and truthful. And where the bar is fearless, it should be able to stand up to certain individuals if, for example, there is need for the bar to say, this person does not merit to be appointed a judge. And the bar has verifiable fact to support it, the bar should put his feet down. And if he needs to boycott such person's court, if such a person is nonetheless appointed, the bar should do that. Where it concerns a sitting judge, even though the bar does not have any role to play in the discipline, the bar can also sustain a petition against such a person. It is neither here nor there. But unfortunately, the society we live in, where the state security services can invade the home of a judge and nothing comes out of it, where law enforcement agencies like EFCC can destroy people's reputation in the media without following it up with charging people to court. The judges are human beings. Sometimes too, it affects their courage in doing their job. And where the bar association, in some years, in the bar association has not in all cases been bold in defense of the independence of the judiciary, or ensuring that the men and women who man the various courts receive the requisite protection that the bar needs to afford them against any form of tyranny. Then you can talk about also the politicization of judicial appointments in some cases. So there are a whole lot of issues. I mean, we need to go do a holistic thing about it, because it starts from the process of appointing, where sometimes people are appointed not because they have what it takes, or because they have the kind of integrity expected of it. And in present mode of having those who want to go to the bench, signifying interest, going around, getting letters of recommendation, amounts to some form of lobbying, even though the rules for guideline for appointment of judges outlaws, lobbying. But in the old times where there was by preferment, the judges see that this lawyer is doing well, he merits to go to the bench, and they recommend such a person and confidentially recommend him. The best hands among lawyers were appointed judges. But now there are cases where some persons who want to go to the bench, because we have to say the truth, are persons who may have failed in practice, or who merely see it as a career advancement, not because they have the burning passion to dispense justice without fear or favor. For some people too, it's a promotion. For example, when we insist that only the most senior must go from Court of Appeal to the Supreme Court, we're not talking about the quality of their work. When we insist that a chief judge of a state will only recommend the senior judges from his court to the Court of Appeal, and yet that same chief judge and NJC have been receiving returns from judges, and they can see the judges from the various courts that are doing very, very well, whose judgments are usually sustained on appeal, whose productivity is very high. But when it comes to appointment, they may be denied appointment to higher courts simply because they are not senior. Let me not go into federal character. Let me assume that the federal character is in their favor. You certainly remember that they are not senior, or that this person had been on the bench for like 5-10 years before he came. How can he go? This person is very old. So it becomes something like title, like becoming the Olubadan of Ibadan. The most senior chief becomes the Olubadan when the Olubadan exits. It doesn't matter whether his health or mental acuity supports that promotion. So we promote based on, oh, he's the most senior person. In the US, for example, I know that their current Chief Justice was not even a judge of the Supreme Court when he was nominated to be Chief Justice. And the Constitution does not limit the appointment of the Chief Justice to serving justices. It also does not say that only people in the Supreme Court, in the Court of Appeal, can go to the Supreme Court. We need to look at these things and know that there is need to bring in fresh persons, young persons who will add much value. Sometimes some people, before having spent so many years at the Court of Appeal, by the time they get to the Supreme Court, they are old, they are infirm, they are unable to really survive the strain of that office. So the answer to your question does not lie with the bar. It lies with the society, it lies with the mindset of the NGC, it lies with political interference in appointment of judges. It lies with interest, the Nigerian way of doing things, where sometimes merit does not count.
Thank you very much, Mazi. You've really done justice to this question. Otumba, do you have a follow-up, or are you okay with the...
Yes, thank you very much for giving me another chance. The point I'm really trying to make is, there's no magic in good governance, in good judiciary anywhere in the whole world. The rule of law is the root of everything, is the key to good governance, be it in any aspect of life. We don't have that. And judiciary, again, is also taken advantage of because there's no rule of law. Because when you see the criminality, the amount of underhand that is going on within judiciary, NJC, and also all that kind of thing, you start asking yourself, these are people that's supposed to put in place.
Do you have a particular, Otumba, I'm sorry, do you have a particular example in mind? Or you are speaking on general terms? Do you have a particular example in mind?
I'm speaking generally.
Okay, generally.
Because
okay.
The biggest problem is as you can see, the General Secretary also alluded to it, that 99% of the problem we are facing and we have is the kind of people we are. And you will also agree with me that without the rule of law, without all these basic things in place, everybody, they're just doing whatever they like. And that's why when you see the kind of interference from the executive sending the DSS to go and raid a Chief Justice home in the middle of the night, that things like that will never happen here. Even if it happened, it will be only one in every 1,000 years or so. So what is NBA doing to address putting in place rule of law?
Mazi.
Well, one of the objectives of the NBA is the promotion of the rule of law. And then I must also confirm that the maintenance and defense of the integrity of and independence of the judiciary is one of the core objectives in Nigeria, one of the core objectives of the NBA. NBA has done several interventions, issuing statements, condemned certain actions of government, refusal to obey court judgment, and even during that time that Honor was about to be removed, the NBA had a court boycott. The jury is out. Many people still feel the NBA could do more. I mean, there's always room for improvement in life. And many people yearn for the return of the Alao Akaba Sharon days of the NBA, where the NBA pulled out all the stops to confront the military of the NBA. NBA also engages the executive and the legislature to ensure that the independence of the judiciary is maintained, and also money meant for the judiciaries. Like I said, we could do better than we are doing presently. We can improve on it. We can only keep hoping that NBA should continue to play the role which it has set out for itself in its constitution to play. Many people may think that it has not done much. Many people also may think it has done more. But for me, the point is that we can do more, and that every effort should be made by lawyers, whether they occupy offices or whether they don't, through the instrumentality of the law, to ensure that the rule of law is enthroned, that the judiciary is not in any way intimidated in the performance of its duties.
Thank you very much. Dr. George Davidson, quickly, please. Dr. George Davidson, do you have your question ready? I've asked you to unmute. Right. Mazi, let's now, I believe we've done justice to electoral matters. Let us now move to judicial reform. Basically, the discussion we've been having tonight is geared towards how do we make the system better? How do we make legal practice better? How do we make the judiciary better? So with regards to judicial reform, first of all, I will, if you don't mind, on 3 aspects of judicial reform I would like you to address. 1, judicial reform with regards to electoral disputes. I'm aware you've done justice to it a little while, but if you just touch on it briefly again. And 2, judicial reform with regards to corruption matters. Deal with the big elephant in the house, corruption. Then judicial reform with regards to speeding up the judicial process itself. Because as we are all aware, everyone knows that justice delayed.
I didn't get the 3rd one. Election matters, corruption cases.
And the speeding up the judicial process. We are all aware that justice delayed is justice denied. So what judicial processes do we need to put in place to reform it, to make judicial actions or jurisprudence more faster for the populace?
Well, I had talked about the electoral process, and I had opined that in some cases, especially in pre-election matters, there may be need for us to look at it a second time to ensure that these cases are resolved before the elections take place, to avoid the anomalous situation where a person who never contested the election is suddenly ordered to be sworn in. And then the fictional finding by the court that he won the highest number of votes, even though the electorate never saw that person as a candidate. And I also opined that we may need to look at the electoral provisions under the 1979 Constitution that allow the chief judges of state to empanel election petitions panels, and which allow them to dispense with these matters before the swearing in. And in many cases also, the appellate processes were concluded. I talked about that, and I reiterate them as a way to go. I do not think the current system makes for speed. I do not think the current system makes for confidence. And we need to also look at the process of the large number of cases that come on appeal. We need to also look at the position where in some cases, some matters should not be able, we need to also look at what kind of matters should go all the whole hog, and look at the continuing need, whether there's any desirability of retaining appeal in the gubernatorial elections to the Court of Appeal, to the Supreme Court, and also whether we shouldn't consider a situation where the entire justice of the Supreme Court hear presidential election petition without it having to go from Court of Appeal to Supreme Court, as is done in many countries. The Supreme Court hears it and takes a decision, and the matter ends there, and within a very short time frame. So when it comes to corruption cases, I think a lot of progress is being made. The hitherto ability of defense counsel to use preliminary objection to prolong cases has been done away by the Admission of Criminal Justice Act 2015. And in various decisions, the Supreme Court has upheld this right. So you see that appellate processes are no longer being used to slow them down. But I'll also tell you another problem we have, and we need to look at that. We have a situation where the ACJA says that criminal trials shall be adjourned from day to day. And my understanding is that that envisages a kind of situation where a court, for example, clears its docket and schedules a matter for a whole week to be able to finish it. So we seem to have adopted the letters of what obtains in some Western countries without adopting the spirit. So a judge insists on adjourning your matter from day to day and has in his docket 17 or 20 other cases. So you may only get what we call, you get a bite. So there may not be ample time. And the issue of what delays the election corruption cases face is also what some other cases face. Sometimes the prosecution's witnesses are not there. Sometimes the prosecution is not fully ready to go on with their case. Sometimes too, because of the loaded dockets of the court, where, for example, they have charged 5, 7, 10 persons as defendants, with each of them having his or her own counsel. You discover that the cross-examination may drag on for days. So in terms of speed, we may have achieved that, but some other things make it difficult for that to be obvious. But also in so many civil matters, I can tell you from my experience practicing there in the FCT, in the High Court of FCT Abuja, There are days you go to court and the plaintiff can open his case and close it, and the defendant will open his case and close it same day. So we see cases being concluded in a matter of months. And also under the FCT civil procedure rules, we have the fast track process, which allows you, if you apply and it is approved and you pay the requisite fee, a matter is concluded within a matter of weeks. So, but when it comes to corruption cases, and I still insist, in as much as it is important that these corruption cases should be pursued with seriousness, we cannot destroy our economy. We cannot destroy the other aspects of our lives because we are pursuing corruption cases. Because the idea of giving so much attention to corruption cases, for me, is bolting the stable after the horses had shutting the stable after the horses had bolted. What we need to do is to look at our budgeting process that allows people to put irrelevant and fraudulent things in the budget that are meant to end up in private pockets. We look at our procurement process that allows people to steal the state blind without any due process of law being on. If you look at if you listen to the nasty stories coming out of the NDDC, NSITF, you have an example where individuals will sit down and be putting money in their pocket. Instead of waiting for these people to finish stealing this money and deploy them for their legal defense, we must take steps to make it impossible for them to steal money in the first place. And we'll not be talking, because it's not when these issues get to come, start starting corruption cases. The corruption cases start from the stealing process. And that is why we should display therefore not in the court. And when we keep shouting court, 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 it is the executive outsourcing their failure to the courts. Because if the executive does the right thing to stop the stealing from taking place in the first place, the judiciary will have very little work to do. And the investigation process too. When you do a thorough investigation, very forensic investigation, a defendant sees that this is an open and shut case, plea bargain may be the only option on the table. So sometimes the short investigation of cases also enables these corruption cases to be delayed in our courts. And maybe there will also be some degree of frankness on the part of lawyers, including myself, who defend some of these cases in appropriate cases, to be able to dispassionately advise our clients about their options and about their chances in these cases. So when we keep saying courts, 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 as if the courts are the cure-all in this matter, to me, we'll miss the point. And then the last thing you talked about, speeding up the judicial process. I also understand it's just the large number of court matters that come to court in Nigeria. Our inability to explore mediation to settle matters, of not taking some matters to court because they can be otherwise resolved. And this could be a function of the fact that, one, the losing party in Nigeria does not bear the cost, the litigation cost of the winning party. Sometimes, for example, I'll give you a simple example. A tenant is owing rent. He knows he's owing rent. And then, fearing that the landlord may want to take him to, he preempts the landlord by claiming that the landlord wants to throw him out. An owing tenant sues the landlord so that he will stop paying rent, so that the landlord will stop demanding for rent. And he may tie up everybody in court for 2 years and nobody gets punished. The court is reluctant to order him to be paying his rent into court. If the court orders it, counsel will file an appeal against that order by the court. The rent be paid into court, pending the determination of the case. Sometimes too, some of these cases that clog the dockets of our court are actually products of willful effort not to allow matters to go. So how do you look at it? Cost in appropriate cases should be imposed on counsel. Disciplinary action could be, a counsel could be recommended for disciplinary action. When it is seen that a matter is really frivolous and ought not to have come to court, cost should be imposed on the losing counsel. The thinking by a judiciary that is against public policy to impose cost of litigation on the losing party should be reviewed as no longer representative of the modern thinking. If you sue me where you have no reason to sue me and made me to incur cost of engaging counsel and defending myself, you should be able to make good my cost. Sometimes people also have arbitration clause. Without utilizing it, they go to court and waste everybody's time. Even in situations where everybody knows that our appeals do not lie to Supreme Court, counsel will go and file an appeal at the Supreme Court. And people walk away from it. Now nothing happens to them. When you're able to remove all these weeds, separating the wheat from the tares, you may be able to declog the judicial process and speed up the judicial process. But sometimes too, in some cases, Nigeria moves fast. In some jurisdictions, a matter may not come to trial for at least 2 years after the filing. In Nigeria, you can file a case and conclude it in 6 months.
Well, all right. I have a lot of questions on this area, but let me allow one of our guests to ask his question. Anna, please, I'm asking you to unmute. If you're able to unmute your phone, and if you can also start your camera so that we can see, but it's optional whether to start your video or not, but right, that's fine. Anna, go ahead.
Okay. Yes, thank you, Mazi, Afam, Osigwe. And it's actually a privilege listening to you. I'm not a lawyer, but I'm a pocket lawyer in my village. So I want to ask, I want to see the activism of MBA in our governance, especially as you know, because you can't have a perfect MBA in a dysfunctional system. That is to say, you can't run faster than the bus you are traveling in. So I want to see MBA getting involved in the way we are governed. I actually want to see the opinions of many lawyers in this contract we are talking about. I mean, with the contract some people in government signed with China, vis-a-vis what is happening in Tanzania and some other African countries. As a banker, I reviewed those, the contracts with the little knowledge, of writing offer letters and all that. And I can't actually express my opinion here, but because I'm not a legally trained mind, we would want to see the opinions of learned lawyers as to that contract. And another thing again, why would MBA keep quiet? Without raising the bar of people who should govern, especially when you know the requirements, of government. It's not a question of advice. I mean, administrators at various levels, like presidency and what do you call it, governorship and local government. We know that these people are going to take decisions concerning lawyers. They're going to take decisions concerning everything about us, healthcare, everything, and they will keep quiet. For people to go and occupy, just, but what I see here in our political space is that people are appointed based on nothing. And we now expect, Nigerians will expect those people appointed to overnight, to grow competencies that will now, lead all of us into lagoon. So I'm really worried. So MBA, I think that MBA should be more, because lawyers are supposed to be learned, and their learning is not restrictive, because when you have issues, lawyers will cover all areas. They should be proactive, not reactive, and MBA should do that to guide us, because actually the way we see things and the way we are going, we are quickly running into abyss, and MBA is keeping quiet. And the funny thing that all of us, all members of MBA, all of us, people both learned and not, will enter the abyss and will go by the way of Antarctica, a continent that never exists. So I want to see your reaction of the learned gentleman to this unlearned opinion.
Oh, well, I'm not sure that sounds so unlearned, but let's listen to Mazi this time.
Anna, thank you. I think your view encapsulates the thinking and feeling of the civil populace as to what MBA should. And I believe that so many lawyers are listening, and I also hope that those who are the helm of affairs of MBA are listening. But if perchance I discover that they are not, I will also convey your sentiments to them. I did say it earlier, the society expects more from MBA. It depends on our perception as to what extent MBA has met up with this. But there's always room for more of it to come from MBA. There's no doubt that is a legitimate expectation from the bar. And there's no doubt that the failure by the bar to live up to this, it's aspiration of the people as to what MBA should do, may relegate MBA to the background. And I hope that both the outgoing and both those who are and incoming persons are also taking note of what you're saying, and if there are areas that need improvement, to improve on them. If the areas that MBA has actually not done much, to put structures in place to ensure that the much that is expected of MBA is not only achieved but exceeded. And thank you so very much, Anna, for that. And you said you were a pocket lawyer, but you didn't come across as one.
Thank you. I have a lot of questions, but our time is right. We will be concluding in the next 5 minutes. So let's take. I think Charles Ude wants to say something more. If you can unmute yourself.
Thank you for giving me the opportunity to ask a second question. Mazi, Afam, there's an area that I think we should be focusing on. That's case management. In order to open the judicial, remove the delay in the judicial processes. The way we file cases, the way we use our registrars, we are not utilizing them very well. In some other jurisdictions, it is to the registrar that we send all processes. They will even summarize it for the judge. And these people are supposed to be already qualified lawyers. So what does that solve? You can't rush to the court with a process that is not in order already. Yeah. They will not list such cases. So, so I want NBA to get involved, not only in NBA matters, things that affect the staff of the courts. See how they can encourage, persuade them to train them. You can, with this COVID era, look at how we are interacting now. Why are the courts not dealing with cases like this? Why should we wait? So a lot of things can change. And I want you to be more active because I like you, you've done a lot of work, but last year you seem to have withdrawn a little bit. So I want you to come out more. We will support you, but factor in case management. Thank you so much.
Thank you so very much for the kind words.
Mazi, basically the question is, how will NBA up their game? Anna, you mentioned something that is very, very, I'm so passionate about judicial activism. What role will NBA, we remember the Alawa Akabasharun, even under the military regime. We remember Ulisa Wakoba under the military regime, IOB, so today, what has happened to our NBA? Because they are still a member of the civil society.
Well, your question seems to suggest that the NBA has been a no-show or has been a gross disappointment in that regard. I may not fully agree with you, but I will agree with you that NBA needs to do more, that people expect much more than they are getting from NBA. And then, and I believe that the only thing that is constant in life is change, and NBA will appreciates that. I read the manifesto of the 3 candidates who ran for NBA president, and I know all of them emphasized it. So, and I believe that Olumide Akpata, who won the election, will do some work in this regard. On the case management issue, many courts have been trainings on case management. I do not know the content of that, I've not been involved, but I agree with you that the bar should be involved in it because we are major stakeholders. We should put the various bar and bench fora we have to use to ensure that some of these measures pull through. And incidentally, I will say this quickly to you. Many courts during this COVID-19 lockdown came up with the idea of virtual court hearing. And many lawyers were the ones kicking against it, arguing that it was unconstitutional. And those who argued that it was not unconstitutional lamented about the poor ICT infrastructure, that they may not be able in all locations to be able to participate in it. And they also suddenly realized that there's a problem. What happens in a situation where you need to tender documents? What happens? How do you tender it in a virtual hearing? We may need to look at some of our laws, update them, bring them in sync with modern realities as obtained in some other parts of the world. But even if Nigeria does not do that, with NBA being one of the driving forces, we risk being relegated to the background. And we need to do more. And the Bar Association, I can hear it loud and clear from those who have contributed, needs to sit up and do more. And like I said, I believe our colleagues are listening, and I will also personally convey these sentiments to people as soon as at the earliest opportunity I have of having a discussion of in this regard.
Final question, please, from Mr. Nicholas.
Thank you very much. Sorry, I came in a bit late. I just 2 questions, really. The last executive body that left faced a lot of controversies, from the elections and to so many issues that were, that came up across the country. I'm wondering whether you people, what are the lessons you took away from it, so that we know if you're going to work on it. Then secondly, on the COVID-19 thing, there are lots of issues of trampling on human rights by government agencies and the rest of them. I had expected NBA to speak up on some of these issues, but we had nothing from them.
Well, let me take the last thing you talked about, tampering on human rights. It may not actually be right. I know for a fact that many branches of NBA sent representatives and offered free legal services to persons who were tried before mobile courts. And they were involved in some of the alleged violations of human rights by security agencies, and also issued statements and intervened in appropriate cases. But then you talked about the controversy trailing this. I keep saying I'm not a serving executive member. I'm just a lawyer in the association who happen to have served the NBA. And then, but all of us are taking note that there's need for electoral reform. And I was glad that his acceptance speech, Olumide Akpata, touched on this and promised to reform the NBA electoral process so that people will have much more confidence, so that the bickering that we experience every time we have an election, it becomes a thing of the past. Everybody appreciates that there is need for us to do more. And I believe that efforts will be made in that direction. And all of us have a duty to ensure that the integrity of our electoral process is maintained, and so that when people win or lose an election, they will go away knowing that the outcome reflects the wish of the people. And so that the litigations and then the bad blood and the acrimony associated with the same will be done away with.
Nicholas, any follow-up or?
No. I think that's enough for now.
Okay. There's a question from Dr. George Davison. Why is NBA always siding with lawyers when there are cases of professional misconduct? I'm sure Mazi has touched on it, but briefly, please, Mazi, just briefly, is there anything you would?
I am unable to understand what he means by siding with NBA, because, like I said, it is the same NBA that prosecutes them, that presents the case against them. NBA receives petition. The problem we have is that sometimes the system does not move as quickly as petitioners would want it, and that is regrettable and ought not to be. We need to make that process work in such a way that those who write petitions do not go away believing that by the delay in having this matter heard or attended to, that is suggestive of the fact that we are trying to protect our own. We do not want to protect our own because one bad apple can spoil the whole or the other apples. So it is in our best interest that we take appropriate actions where there's need to take one, but at the same time, we'll not throw a lawyer under the bus simply because a person expects us to. And some of the things that are written as petitions actually fall out of commercial transactions that do not qualify as professional misconduct. So we cannot also do something to please every person, because the lawyer is also entitled to fair hearing and to justice. So we have to, the NBA and the LPDC have to be sure that disciplinary action is merited before meting it out.
Thank you very much. Omage, please, seriously wants to make a comment. So let's hear from her. Omage, please.
Hi, everyone. Sorry.
Please
Hi, everyone. Yeah.
Hi.
So a great presentation. I want to thank Mazi, Afam, Osigwe. Very insightful session. But I must say this, that NBA has a very pivotal role to play in moving not just Nigeria, but the whole of the African continent forward. And the earlier they begin to take up this role and begin to move in this direction, the better it will be for all of us as a country, for the legal profession and all that. So I want to categorically state that the world is fast changing, and the NBA must know that we must move on with the world. So I want to see an NBA that kind of prioritize relationship, building relationship. There's no way you can do this without collaboration and building relationship and doing the groundwork to address important issues. They have to have allies. They have to build allies. Look at the law school. When was the programs updated? When was the last time the curriculum was updated? Look at the courts. You're talking all these problems. The NBA has a very, very important pivotal role to play. And as lawyers, senior lawyers, I believe you and every one of us have a serious role to play. The world is moving. You just talked about the virtual courts and all that. This is the new normal. Who knows? Another pandemic might come. Yeah, that is the world we live in.
Thank you very much. Thank you very much.
Thank you so very much.
Yeah. Mazi, how do you respond?
Well, I mean, I have nothing more to add. She just hit the nail on the head. She captured it aptly and succinctly, and it's an advice that is better taken than ignored.
Thank you very much. We don't have more time to take questions from me. One thing I would like to suggest is if we can encourage the incoming MBA executive to pursue seriously the issue of law reform and judicial reform. I have loved to make comments regarding to our President, Attorney General of the Federation, whether he is up to the task. He's been there now for 6 months. It appears that the question of law reform or judicial reform certainly have no bearing, makes no impact with him at all. There are suggestions some of us would like to make. Is it possible for the Nigerian Bar Association in the issue of reform to ask not just lawyers, but Nigerian lawyers abroad in the United States, in the UK, to make suggestions as to what they would like to see? Let me just say this briefly. I had a case two years ago where I was arrested in Nigeria. So it afforded me an opportunity. I was called to bar in 2000. So but I practiced for only 1 year and left Nigeria. And then I came back 2 years ago and experienced what the court is like. Well, let me not talk about that here. But is it possible, from what the things I saw, is it possible for the MBA to ask people, not just lawyers in Nigeria, to make suggestions on what they would like to see as improvements in the Nigerian judicial system? And then with that, you can give us your parting comments, please, Mazi.
Then every lawyer you ask will agree with you that there is need for there to be improvement in the Nigerian judicial system. It's how to go about achieving it. And there are constitutional constraints. And I can tell you for free that there are a number of bills proposed for, there are a number of recommendations for the reform of so many bills by Nigerian Law Reform Commission, having worked extensively with various lawyers from all spheres of life. Or sometimes if you know the lawmaking process in Nigeria, you will not blame the slow pace of work. The accusations that some bills are passed on the basis of pay to play, is that how they call it? And so there's a lot to be done. Even the Legal Practitioners Act, the bar has found it difficult to get passed by the National Assembly. But a whole lot can be done. The way to go about it is what I believe the political leadership of the bar and the judiciary will be able to fashion out so that they can achieve that. But there is every need for us to find the right points and to push them through for our own enlightened best interest.
Thank you, Mazi. It's been a 90 minutes intense engagement. We planned for 60 minutes, but we are here. It's 90 minutes now. Thank you very much. We look forward to having you again on this platform. And we thank everyone who has been here, those who have stayed till the end. It's impossible for me to mention all of you by name, but please take this as my thank you to all of you, those that asked questions, those that listened, those that made comments on our chat system. I'm reading all of them, and I'll compile them into a report. Thank you all very much. Thank you, Mazi. It's been a very real pleasure having you here tonight.
Thank you so very much. I appreciate it.